Hi, my name is Christopher Eustace. I'm in the digital forensics course, majoring in IT, networks, and security. For my presentation topic, I chose the topic of digital forensics with a focus on civil litigation. In my spare time, I like to, study the law. I'm not a licensed attorney, but I've represented myself in a number of civil cases. So I'd like to say I have a fairly good understanding of civil litigation in that context. So I'm going to start going through the PowerPoint for Chapter 7 over the admissibility of digital evidence, and I'll essentially elaborate on some things mentioned in the PowerPoint because they are kind of generalized statements, and some of them are actually not completely correct. So I'll go into detail about things that come to mind when I'm reading this PowerPoint, as well as I might pull up some information through like a Google search to kind of elaborate on some of these topics. So to begin these objectives, I might skip through these. Review the structure of the legal system in the United States. Okay. Constitutional law. Okay. So you have federal constitution. Well, you have the U.S. Constitution, and each state will have a constitution. They're often very similar to the federal Constitution, but there are differences, and it varies from state to state. You have different rights under different state constitutions, and different procedures to enforce your rights. So, search and seizure, understand case law, so legal precedents concerning the use of digital surveillance devices by law enforcement. Okay. Guess getting search warrants and whatnot. Computer forensics gone wrong. Structure of the legal system in the European Union. Okay. Those state and federal laws. This is true. Impact criminal investigations and court trials. Moreover, investigations and court proceedings at the state and county levels are influenced by the Constitution, which is a federal document that protects the rights of the individual. Okay, this is true. It doesn't mention, the state constitutions, which are sometimes as equally or more important. A computer forensics investigator must abide by federal and state laws. This is generally true. They are protected, if they're working for a government agency or entity, they're usually protected by different kinds of immunity. They might have qualified immunity if they're like a police officer, or if it's like a state entity, like a public university, or like a state police, they have sovereign immunity, which is kind of a different thing. It's more for like a larger state entity. So even if they violate someone's rights and violate the law, they can often get out of legal liability. They're able to get lawsuits dismissed by raising those affirmative defenses. So they don't always have to follow the law, essentially, but they can be held liable if they knowingly violate clearly established law, or if they're plainly incompetent is another legal standard. So they can essentially get away with violating the law in certain situations. Okay, so a case can be tried in a number of different ways. In a criminal investigation, a jury might find they're not guilty. A jury is people put under oath to hear evidence in trial and render a verdict of guilty or not guilty. Okay, so this is referring to a criminal trial. So in that context, you could have a jury trial or a judge trial, which could also be considered a bench trial. In a jury trial, the jury would have to unanimously convict the accused person, and this is in a criminal case, of course. And at that point, the judge would sentence the accused person. So the judge kind of plays two roles in a criminal jury trial. One, they facilitate the process of the trial, according to the law. So they'll allow certain evidence in, keep certain evidence out. There's going to be motions, pretrial motions. The judge rules on all of those. So a lot happens in a legal proceeding, going up to the trial. And oftentimes, cases are settled before trial more often than they go to trial. So even in a criminal or a civil trial, these cases get settled through settlement agreements or plea agreements all the time, and it's more common for cases to be resolved that way than not. Trials are actually very rare occurrences. If you were to have a judge trial for a criminal case, the judge would essentially play all roles of, facilitating the trial in accordance with the law, rendering a verdict, and then the third thing would be sentencing someone. So the judge does everything in a bench or judge trial. It's known by both terms. And that also applies in a civil context as well. You can waive your right to a jury trial, and the judge will, perform all three elements in a civil trial, which would be facilitating the trial in accordance with the law, all the pretrial motions, letting certain evidence in, keeping certain evidence out. They'll render a verdict whether the plaintiff, is owed legally compensable damages. And the third thing they'll do is determine what damages are owed to the plaintiff. So in a jury trial in the civil context, you'll have a jury of sometimes 6 to 12 people, and unlike in a criminal trial, the jury does not have to reach a unanimous decision in a civil trial. In a civil trial, in most cases, you'll have a 2/3 margin where 2/3 of the jury have to reach a decision of whether the plaintiff should be compensated or not under the causes of action that they're pursuing against the defendant. Once that is determined, the jury also awards damages. So they also determine what the plaintiff is owed. And many people often wonder, if the jury does all this work in a civil trial, what's the point of having the judge? Well, the judge does all the, the judge handles the pretrial motions, and they facilitate the trial in accordance with the law. They'll handle objections in the courtroom, keep certain evidence out, let certain evidence in, and they're kind of like the gatekeepers to the trial process. Okay, in a civil lawsuit, it can ensue with a victim seeking monetary compensation against an offender or third party for physical damage or emotional distress. These are some of the things you can sue for. There are often other categories, non-tangible things, monetary damages, lost wages, all kinds of things. Okay, so the plaintiff is the person who initiates the lawsuit and is responsible for the cost of litigation. Okay, this is actually very rare that the plaintiff would be held responsible for all costs of litigation. It's a complex issue, but to start, I'll kind of go into the American system, American rule, attorney fees. Okay, so in America, you have two opposing sides in a civil trial. You'll have a plaintiff and a defendant. And generally speaking, each side bears their own costs throughout the proceeding. And at the end of the proceeding, a prevailing plaintiff can often recover their attorney's fees and court costs. It's very rare for a defendant to recover their attorney fees and court costs, even if they successfully defend the case. The two things that generally allow recovery of attorney fees under the law are, one, if you have a contract that allows you to recover attorney fees under the contract. So the plaintiff might have had a contract with the defendant, and at that, under that contract that they agreed to, and it may be in writing, like an express written contract. It may be signed by both parties. Under that contract, it may provide for the award of attorney fees to the prevailing party. The second way that you can recover attorney fees under the law would be through a statute that authorizes the recovery of attorney fees. And when we say statute, oftentimes it's referring to, a certain cause of action that you can sue under. Many causes of action that one can, sue under. You might have like a Americans with Disabilities Act claim. So under each of these causes of action, you'll have statutes that allow the award of attorney fees. And in this context, it's generally very plaintiff friendly. These statutes for all kinds of causes of action that you can sue under allow the award of attorney fees to a prevailing plaintiff, and very rarely, I've never seen an example of a statute that awards attorney fees to a prevailing defendant. Although if they successfully defend against a case that could be perceived as very egregious and completely frivolous, brought for an improper purpose, such as to harass the defendant, in a very egregious case where it's just a completely meritless lawsuit, the defendant could ask for sanctions against the plaintiff, and one of the sanctions that might be available would be the award of attorney fees. But that is very rare, and in most cases, the defendant is not able to recover their attorney fees. However, under the statutes, most prevailing plaintiffs will be able to recover attorney fees under a lot of the causes of action they could pursue. So okay, the defendant, yes, that's true. Okay, history and structure of the U.S. legal system. The U.S. Supreme Court, U.S. Court of Appeals for the Federal Circuit, U.S. Court of Federal Claims. Okay, these are claims against the U.S. government. So if a plaintiff has a claim against the U.S. government, for example, I'm in Houston, Hurricane Harvey, the flood litigation against the U.S. Army Corps of Engineers was in the U.S. Court of Federal Claims, and that is because the United States was a defendant in that case. Most civil cases will go through U.S. district courts, and if you want to appeal a decision made in a U.S. district court, this is a trial court. Trials are held here. And if you want to appeal a decision made by a judge in this court, you'll appeal to the Circuit Court of Appeals. Here in Texas, we're in the Fifth Circuit, and that includes Texas, Louisiana, and Mississippi. And this is often the highest level court that you're able to appeal to. You could, if you don't like a decision made by the Fifth Circuit Court of Appeals, you'll, probably first get a 3-judge panel, but you could request an in-bank rehearing, which is through the, a hearing with every single judge of the Fifth Circuit. So instead of a 3-judge panel, you'll have, I think there's like 12 or 18. There's a lot of judges, so could have all the judges decide it. But if that doesn't work, you could try to appeal to the U.S. Supreme Court. They very rarely grant appeals. It's called a writ of certiorari, and they very rarely grant those. So most times they won't even review your appeal. So it's the primary means to petition for the U.S. Supreme Court to review. So if it doesn't grant the writ of certiorari, they basically don't even review your appeal. So I think the rate at which they grant that is less than 1% of people who appeal. Rate of percentage denied. The success rate is 2.8%. So in 97.2% of cases, the party appealing to the Supreme Court will not have their appeal reviewed. So it's kind of a long shot to ever appeal to the Supreme Court. So in the Court of Appeals and the U.S. Supreme Court, they don't ever hear trials. They just make decisions, legal decisions. Sometimes they'll review the facts, but in most cases they're just reviewing the law and how the law was applied by the trial court, the district court down here. So it's mostly, they're reviewing motions and rulings made by the judge down here in the district court. and they can reverse decisions made by the district court. They can reverse and remand, and send matters back down to the district court, send matters back down to the district court for trial, or they can uphold decisions made by the district court. And that sometimes happens, and sometimes it doesn't. So, what is this? The Federal Circuit. Does that include the DC Circuit? There's a DC Circuit. No, I think that would fall into here. So there's a DC Circuit Court of Appeals. It's basically for legal disputes in the Washington D.C. District of Columbia. This is true. However, cases are often decided in pretrial motions, so you might have a motion to dismiss in a federal case. It could be brought under Rule 12B, or you might go through discovery and exchange, evidence, and at that point you'll have an evidence-based motion called a motion for summary judgment, and that could completely dispose of a case prior to trial. So yes, this is true, but cases can get dismissed or thrown out prior to trial through pretrial motions. So that's not always the case. You don't always get a jury trial in every case. But when you do go to trial, you do have a right to a jury, and only, I guess in a criminal case, you can waive that. If you're a defendant, you can waive your right to a jury trial and go before the judge to have a judge trial. And in a civil trial, I think if both parties waive their right to a jury trial, then you can have a judge trial in a civil case. And that's how that works. Okay, so voir dire, it's a questioning process, yes. So before you select your jury, you don't really select a jury, you kind of deselect jurors. So you'll have a pool of jurors, and you can ask them questions and kind of figure out, what their life experiences and views are on certain things. And once you're able to, learn more about these people, you can deselect them if you think they are likely to be an unfavorable juror. If you don't think they're going to side with you, you can basically get rid of them, and each side gets a turn, and it goes back and forth until you have, it could be 12 people on your jury, it could be 8 or 6. It really depends sometimes. Yeah, civil trials typically have 6 jurors. It can be 6, 8, or 12, I think. Sometimes you have 10. It really varies from court to court. All defendants are presumed innocent until proven guilty beyond a reasonable doubt. That is the legal standard in a criminal trial. In a civil trial, the standard of proof is a preponderance of evidence, which is 50% and a feather. So whether something is more likely than not. So if you get to like 50.1% likelihood of something, that is enough to say it's true in a civil trial. However, in a criminal trial, you don't want to send innocent people to prison, so there's a much higher standard of proof, and that is guilty beyond a reasonable doubt. Criminal felony trials are 12 jurors, yes. With felony trials, you usually have 12 jurors. You don't want to have 6 jurors in a felony trial because there's too much at stake. If you have a misdemeanor trial, I think you might have like 6 or 8 or 10. Yeah, so, and there's 6 sometimes during trial, or with others and may not read about the case. Yes, they're often instructed not to read news articles just because those news articles might contain certain things that were ruled inadmissible in the case, and the judge doesn't want the jurors to be prejudiced by something that isn't admissible in the case. Okay, so law enforcement must obtain a warrant issued by a judge or magistrate before a search or arrest can be carried out. That's not always true. They can make a search or make an arrest if they have probable cause, which I believe the legal standard is if it's more likely than not that a crime has occurred. I think that's the legal standard for search or arrest. It's much lower than the standard for convicting someone, but that's just how the system works. Okay, so a search warrant is a court order issued by a judge or magistrate authorizing law enforcement to search a person or place, as well as seize items or information within the parameters of the warrant. That is true. I don't really have much more to say about that. Okay, an investigator must demonstrate probable cause. Okay, so if you're trying to get a warrant, yes, you would want to be able to demonstrate probable cause. Probable cause refers to the conditions under which law enforcement may obtain a warrant for a search or arrest when it is evident that a crime has been committed. Yes, that is true. They can also make a search or arrest without a warrant if they have probable cause. So in a way, a warrant can sometimes just be a moot item, but oftentimes they will go ahead and try to get a warrant if they can. Okay, so email is probably the most important type of digital evidence. It is continually addressed in many cases. Okay, email is a written record. It's often admissible in civil and criminal cases. So yes, it can be very important. Be careful when you send emails. Okay, so case law concerning the use of digital surveillance by law enforcement. Stingray is the generic name given to a device that acts like a cell phone tower to locate criminal suspects. It can also be used to locate people in disaster areas such as earthquakes. Okay, so what is this? Pin register, use of GPS, acquisition of digital evidence during a traffic stop. Okay, the Congress writes the laws. Yes, that's the legislature. Federal courts interpret congressional legislation. Yes. and pass judgment over those who violate those laws. Yes, that's true. Oftentimes a statute written by Congress, they write the statutes are vague, and it's left to the courts to interpret those statutes, and what we end up with is these court rulings that become law through legal precedent, and legal precedents hold more weight when they involve cases with very similar fact patterns. They also hold more weight when they are within your own jurisdiction, or made by an appeals court or the U.S. Supreme Court. Those higher level courts, their decisions are much more important, and for example, the U.S. Supreme Court, when they make a ruling on something, their precedent is binding, it's legally binding over the whole country. Whereas a decision made in our circuit here, the Fifth Circuit, would be legally binding over the Fifth Circuit, which would be Texas, Louisiana, and Mississippi. But it wouldn't be legally binding precedent in another circuit, which could be, in California, I think is at the Ninth Circuit. A decision made in our circuit, the Fifth Circuit, could be used as persuasive authority in California if there's a case with very similar facts, and there's not another case in California that has the same facts. That case from over in the Fifth Circuit here could persuade a judge to make a certain decision over in California, but it won't be a legally binding precedent, if that makes sense. So changes in technology have brought about changes in legislation. Yes. All of these acts, FISA, remember, what was it, Russia, yeah. Computer Fraud and Abuse Act. What is it? U.S. Patriot Act, after 9/11, I think. Protect Act. DMCA, Digital Millennium, yep. That is involved with copyright infringement. All right, so rules of evidence admissibility. Okay. I actually wish I knew more about these. Know about federal rules of evidence. Hearsay. It's supposed to be inadmissible, but it gets in there a lot. There's different exceptions to hearsay. You might have like a statement by a party opponent. So say you're the plaintiff in a civil case, the defendant sends you an email admitting to something, you can use that as evidence against them. Although it's technically hearsay, there is an exception to hearsay. There's, I think, close to 20 different exceptions where you can get hearsay admitted into, criminal and civil trials. So, yeah, expert witnesses. Basically, if you need to prove, basically you need an opinion from an expert to establish something as fact in a trial. You can hire expert witnesses to testify. They're often experts in certain fields. For example, in like a murder trial, you might have like a forensics expert, like someone that can discuss like DNA or something like that. Someone with a background in sometimes an area of science where they can conclusively say that something is fact. This person left their DNA here. What the probability of a false match of DNA would be, that kind of thing. Best evidence rule. So if you have original copies of something, that's often the best evidence available. So courts prefer original copies. They don't like copies of things, but that can be problematic at times. So this actually is not always upheld by courts. Oftentimes they allow copies. I would even go as far to say as more often than not, they would allow copies in to court, like a copy of an email or like a copy of a receipt or something. Instead of the original, you could scan it and have a copy. A digital record, oftentimes you'll have documents that are e-filed in court, so digital records are very prevalent these days. Okay, so we have the European Union. I really don't know much about the European Union. I don't live there, so I'll just skip over that. Okay, so how much time do we have left? Oh, wow. Okay, 36 minutes.